suspension. But I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
Oh, okay.
There was never a suspension on his license at all. He's been good to drive.
He was also drinking.
Well,
But the concern was that he was drinking. And
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, this should be eligible to you.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on the license. It's the IC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
And does he have an interlock as well?
Yes, Judge, yes, interlock, he was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit.
This is where the temperature rises. The defense claims the don't drive rule was built on faulty info. The judge isn't buying that. He's locked in on one question only. Was there a court order, and did the defendant follow it? At this point, it's no longer about forms. It's about who holds the power in the courtroom.
On file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
It was a suspension,
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email?
This is the moment everything shifts. The defense insists pre-trial services said it was fine. That argument goes nowhere fast. Judges don't accept advice as permission. Court orders aren't suggestions, and they don't come from staff. They come from the bench.
Or the dismissal ordinance from jurisdiction, because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
We
you.
were suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
12/6/2024, end
Herrera?
date 6/3/2025, and the lift date comes in at.
And then if that,
Not saying you're wrong, what I'm saying is, based on what I can see, is what, all I can see.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't.
This is textbook courtroom tension. The defense keeps pointing to paperwork. The judge keeps pointing to authority. And the message is blunt. Even if the system makes a mistake, you don't get to ignore a direct court order and do things your own way.
Don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, A court order is a court
I
order.
understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right?
Class A license, Judge.
I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand?